I am delighted to be here today with all of you to talk about my personal favorite subjects, research and writing. Now, that may sound to you boring, and that may have been your absolute least favorite class in law school. It was mine, least favorite class, but I will tell you, that also is foundational to our very profession. So, research is one of the most important things that we do as lawyers. I mean, after all, really, what do you know as a lawyer if you don't know what the law is? So, cases, statutes, regulations, they all are the playbook for every single argument you've ever had and every single case that you will ever do. They identify the rules, they tell you everything that you need to know. And I've always thought that really research is not so much a tool as it is a quest. It's a quest for you to find out what you need to know. And you, of course, are the sleuth. So if you smoke a pipe, I think that's always good. But the magnifying glass here really is important. Because if you use a magnifying glass, you will discover things. Don't laugh at me, Tess, stop that. You will discover a whole microcosm of things, in fact. One of my favorite words, the definition of which is a community, place, or situation regarded as encapsulating in miniature the characteristic qualities or features of something much larger. And that is very, very true, because research really isn't about dry words on a page. If you use your magnifying glass and you immerse yourself into it, you discover policy, you discover personality, you discover societal norms and quests to enforce behavior or change behavior. So truly, I mean, you've all heard it, it's such a trite thing to say, but it's true that the law lives and breathes. You are part of it. You help make it. You and the clients that you represent. I can't think of anything more exciting than that. So, in my own view, speaking of immersion, I've always considered research to look something like that. It's a bowl of jello, something into which you must immerse yourself. Except that your research or your jello bowl doesn't look like that, it looks like this. Anyone's grandma ever make that for you, make you eat that? What a terrible marketing idea, but nevertheless, it is a very good depiction or visualization of what research really is. It's messy. There's lots of stuff in there. And your job is to find that olive that's down there at the bottom to the left. So you need to get out your spoon, you need to dig around in it and push the carrots away to get where you need to go. Now, legal writing. Why is this important? I could go on and on about this all day long until everybody in this room is fast asleep. My daughter and I waged epic battles over her texting. Like, you don't even use complete sentences in that thing. To me, the written word is one of man's greatest inventions. There are so many talents and skills that go into making a good lawyer. Everybody in this room has some skill that they've either honed to excellence through long practice, or it's just sitting there in you waiting to be born. And I will tell you that legal research and writing is right up there among the top echelon of important things in your career that will advance both your career and your client's success. And why is that? Because in the whole of human history, it is the written word that has recorded that history. Because the written word is an enduring reference for what has happened, what will happen, what we agree upon, what we don't agree upon, and how we conduct ourselves going forward. Written words form contracts, constitutions, statutes, regulations, court opinions. Words on a page matter because they are permanent and they are powerful. That is some powerful, permanent writing from a really well-known author. But extreme example, but you get the point. So your writing often will be your first opportunity to inform or to persuade. So if you give a partner or a client a memo, then you've done your job as an educator. If you give the court a well thought out, well researched memorandum of brief, then you've done your job as an advocate. So that memo that you write sitting there slaving away in your office might well be the reference for a future argument. And that brief that you're killing yourself to get the citations right on might well be the reference for a legal opinion. And the legal opinion then goes into the textbooks for everybody else. So if you are a brief writer, make no mistake, ooh, Troy Bolton, you are a playmaker. You can tell I have a 15-year-old daughter, right? So how do you be a good researcher? Point number one is don't believe Westlaw. So, I see this comes up on the Westlaw all the time, this bar graph that's supposed to tell you how, deep this case goes into what you're looking for. Don't believe that. That's just silly. You have to look at the cases and use your own brain. So point number two is, don't rely on the headnotes for either your proposition or for your research tool. So it goes without saying that, obviously you're never ever going to use something that appears in a headnote as a proposition in a brief. That's just the mistake of all mistakes, because you just really have to read the case and know what's in there. But the other thing is that, the Westlaw, when I was growing up as a lawyer, Westlaw used to be pretty good. At least in the headnote searches, you could be more or less confident that you'd sort of found a path. So you can direct your research and feel pretty confident that you'd found everything. And that's just not true anymore. For one thing, the Westlaw headnotes are often way too broad. So for example, one thing that comes up with us all the time, how are attorney's fees determined in a class action? Well, there are a whole bunch of subparts to that question. And to me, they're pretty divisible, but Westlaw doesn't do that. It lumps everything into one giant, ubiquitous headnote that's called allowance and payment from funds in court. You look at that, 844 cases there. So it's not all that helpful. Westlaw also can break up sub-issues or context too much. So, for example, let's say that your issue is the economic loss doctrine. That's another thing we deal with all the time. You see that phrase in a case, or you see it in a treatise, and you go, well, okay, there's my search term. And look, Westlaw even has a headnote for that. But not all economic loss doctrine cases fall under that headnote. For some strange reason I can't fathom. So, like this Crowder case, for example. That case actually is the very first case in which the Missouri Supreme Court adopted what is Missouri's iteration of the economic loss doctrine, and you don't find that case under that headnote. You find it under premises liability developers and builders. You would never think to look there. And, so kind of the bottom line is you can't use these headnotes too much for your search tools anymore. It's probably better to use more of a everyman language type approach. The other thing is that Westlaw misses a lot. Another recent case from a recent experience that I had was there was a big summary judgment, and my issue was duty. So, I'm trying to find cases in Kansas telling me when is a duty imposed and when isn't a duty imposed. So I put in this really broad search, and I come up with 302 cases. And among them is not this Krug case, which is the absolute perfect case that I could ever possibly find that was even within the context of the circumstances in which I needed it. So that's not under negligence, it's not under duty, it's under agriculture. There again, some head note, who would ever look to search there? I would not have. I just happened to find that. So plain language search is probably a little better than trying to stick with head notes. The other thing that you can do, and I think this is useful, is to use the table of contents feature. This is one thing I think is good. It used to be just in the books and the digest, and it's very helpful to go through this table of contents feature that will help you sort of think about, well, what issues maybe am I missing? Where else should I look? The other thing that you must do to be a good researcher is to go long and go deep. So again, you have to think of yourself as the sleuth. It's really you against the unknown, and your attitude should really be one of demand for the answers. So how do you find them? First thing you do is you always read the cases cited in the cases. That is how you uncover the how of precedential development, and that may be very important to you. So let's say that you are looking for whatever proposition you need, and you find something in a federal case. You have state law proposition X. You can't stop there. You got to look at the cases that have been cited, because what that court really is doing is making an eerie guess, an eerie prediction on what state law is. So when you read the cases cited in that case, you find out, well, shoot, those don't really support this at all. And what the court really is doing is acting as its own advocate. The other thing to do, you must always do, is understand what you are reading. The what, why, when of this decision. In other words, what is the real issue here, and what does this holding really depend on? And that can make a big difference. So let's say that you're on summary judgment, and there's this really horrible case that your opponent has cited, and you read that. Well, was that case decided on summary judgment, or was it a dismissal? It may just be a horrifying case. But you can distinguish it easily just by saying different context. That was on dismissal, and we're on summary judgment, so the facts matter for me where they didn't for this case. The other thing you need to do really is burrow yourself down into the facts of every case that you read. Put yourself into that case, because you're not really just reading, you're interpreting. I draw pictures. I do. I line up the cars or telling me where things are lined out in the case law, because I want to feel the thing. I want to get in there and really understand it. And so once you've done that, you bring that case into your facts and apply it. Other than case law, the other thing that requires interpretation, statutes, rules, regulations. So when you're reading statutes, you never, of course, ever just look at the statute that's really at issue. You have to look at that one. You have to look at all the definitions. You need to look at that statute plus all the other statutes that make up the act, right? That make up this body of a legislative act. You also should think about what may be comparable to this. And you go look at those statutes and see if there's different wording. Because once you've done your research and you understand the rules of statutory construction, you know that the court is presumed, the legislature is presumed not to have taken a meaningless act. So, if this word is different than this one, then there's an argument point. For federal regulations, one of the very best sources that you can have is the Federal Register. Because federal agencies have to publish proposed rules for a certain period of time for notice and comment. And so you can read all comments that people send in about this proposed rule, and you can read the responses to those comments. It's a great little avenue for interpretation, because what the agency thinks this thing means will be entitled to a fair amount of weight in court. So, overall points on how to be a good researcher. Let yourself sink into it with full immersion. It's like a bowl of Jell-O. Be curious and be demanding. And don't be satisfied until you've found the olive. Now, how to be a good writer. So the better question is how to be a good anything. One thing that comes up with us all the time, how are attorney's fees determined in a class action? Well, there are a whole bunch of subparts to that question. And to me, they're pretty divisible, but Westlaw doesn't do that. It lumps everything into one giant ubiquitous head note that's called allowance and payment from funds in court. You look at that, there's 844 cases there. So it's not all that helpful. Westlaw also can break up sub-issues or context too much. So, for example, let's say that your issue is the economic loss doctrine. That's another thing we deal with all the time. You see that phrase in a case, or you see it in a treatise, and you go, well, okay, there's my search term. And look, Westlaw even has a head note for that. But not all economic loss doctrine cases fall under that head note for some strange reason I can't fathom. So, like this Crowder case, for example. That case actually is the very first case in which the Missouri Supreme Court adopted what is Missouri's iteration of the economic loss doctrine, and you don't find that case under that head note. You find it under premises liability developers and builders. You would never think to look there. And, so kind of the bottom line is you can't use these head notes too much for your search tools anymore. It's probably better to use more of a everyman language type approach. The other thing is that Westlaw misses a lot. Another recent case from a recent experience that I had was there was a big summary judgment and my issue was duty. So, I'm trying to find cases in Kansas telling me when is a duty imposed and when isn't a duty imposed. So I put in this really broad search and I come up with 302 cases. And among them is not this Krug case, which is the absolute perfect case that I could ever possibly find that was even within the context of the circumstances in which I needed it. So that's not under negligence, it's not under duty, it's under agriculture. There again, some head note, who would ever look to search there? I would not have. I just happened to find that. So plain language search is probably a little better than trying to stick with head notes. The other thing that you can do, and I think this is useful, is to use the table of contents feature. This is one thing I think is good. It used to be just in the books and the digest, and it's very helpful to go through this table of contents feature that will help you sort of think about, well, what issues maybe am I missing? Where else should I look? The other thing that you must do to be a good researcher is to go long and go deep. So again, you have to think of yourself as the sleuth. It's really you against the unknown, and your attitude should really be one of demand for the answers. So how do you find them? First thing you do is you always read the cases cited in the cases. That is how you uncover the how of precedential development, and that may be very important for you. So let's say that you are looking for whatever proposition you need, and you find something in a federal case. You have state law proposition X. You can't stop there. You got to look at the cases that have been cited, because what that court really is doing is making an eerie guess, an eerie prediction on what state law is. So when you read the cases cited in that case, you find out, well, shoot, those don't really support this at all. And what the court really is doing is acting as its own advocate. The other thing to do, you must always do, is understand what you are reading. The what, why, when of this decision. In other words, what is the real issue here? And what does this holding really depend on? And that can make a big difference. So let's say that you're on summary judgment, and there's this really horrible case that your opponent has cited, and you read that. Well, was that case decided on summary judgment, or was it a dismissal? It may just be a horrifying case, but you can distinguish it easily just by saying different context. That was on dismissal, and we're on summary judgment, so the facts matter for me where they didn't for this case. The other thing you need to do really is burrow yourself down into the facts of every case that you read. Put yourself into that case, because you're not really just reading, you're interpreting. I draw pictures. I do. I like line up the cars that are telling me where things are lined out in the case law, because I want to feel the thing. I want to get in there and really understand it. And so once you've done that, you bring that case into your facts and apply it. Other than case law, the other thing that requires interpretation, statutes, rules, regulations. So when you're reading statutes, you never, of course, ever just look at the statute that's really at issue. You have to look at that one. You have to look at all the definitions. You need to look at that statute plus all the other statutes that make up the act, right? That make up this body of a legislative act. You also should think about what may be comparable to this. And you go look at those statutes and see if there's different wording. Because once you've done your research and you understand the rules of statutory construction, you know that the court is presumed, the legislature is presumed not to have taken a meaningless act. So, if this word is different than this one, then there's an argument point. For federal regulations, one of the very best sources that you can have is the Federal Register. Because federal agencies have to publish proposed rules for a certain period of time for notice and comment. And so you can read all the comments that people send in about this proposed rule, and you can read the responses to those comments. It's a great little avenue for interpretation, because what the agency thinks this thing means will be entitled to a fair amount of weight in court. So, overall points on how to be a good researcher: let yourself sink into it with full immersion. It's like the bowl of Jell-O. Be curious and be demanding. And don't be satisfied until you've found the olive. Now, how to be a good writer. So the better question is how to be a good anything. So first you start with raw material, and then you add desire and practice. To be excellent at anything, you must want excellence. And even raw talent won't get you there unless you practice. This guy threw 1,000 shots until he could hit the basket every time. In legal writing, you don't always hit the basket every time, but there are things that you can practice, and over time, excellence will develop. So number one, begin at the beginning. Who is your audience and what is your goal? Who you're writing for and the purpose of it makes a difference. So for example, as to legal memorandum, does the partner just want the law, or does the partner want your analysis? Is this memo going to be used for education? Is it going to a client? If so, you need to ask, what's the purpose of this? What are we trying to do or to convey? If it's for true education, then you need to include all the words. If it's for the file, you need to be as detailed as possible because you're writing for posterity. If to an opposing party, you must be not only accurate, but you need to think ahead. Because again, the written word is permanent. So you need to be careful in what you say. If it's an insert to a brief, make it brief-worthy. As to legal briefs, really kind of the big question is, who's my judge? How busy is that judge? And does he or she have a law clerk? Because that's going to make a big difference to your presentation. So if you're in state court, the answer is obviously yes, this judge is very busy and probably not doesn't have a law clerk. So you make it short, sweet, put all your important stuff up front, bullet point if you have to, because the judge just doesn't have that much time. Federal courts normally do have law clerks, and those law clerks are a lot of times former law review editors, so again, that affects your presentation. Next, ask yourself, who are you, and what is your goal? So, in legal brief writing, one of the things you need to understand from the very beginning is, are you the affirmative or defending party? Because those positions have different goals. So for example, if you win at trial, you become the appellee or the respondent on appeal. So that sort of sounds like a defensive position, but what are you defending? You need to know what your standard of review is before you can answer that question. So if it's a de novo standard, the thing you're defending is the law, the rightness of the decision below. If the standard of review is an abuse of discretion, you're really not defending so much the rightness of this, but trying to confirm that it wasn't wrong. So they're different positions, and the themes will be different. When you're in a defensive position, it's usually, I find, a good strategy, just go ahead and follow the order of your opponent's brief, because that's just easier for the judge. But don't do that if a different order is better for you. You need to kind of figure out what your strongest arguments are and what your best flow is, and use that your own if it's better. Don't ever assume that your opponent has correctly identified the issues. Don't follow a straw man path. You have to think critically and decide for yourself what is the real issue here. Generally, I would say be as affirmative as you can in your arguments. So for example, you could say the district court did not abuse its discretion. That can be your theme. Or your theme can be the district court properly exercised its discretion. That's more affirmative, but that's more dangerous. So if you're on less than really solid ground in the decision below, that first one is probably best, because you can use that standard of review as a prop to your argument. So next, what is your tone? What is the tone of your brief? So first here, snarky is almost never good. Judges just hate that, and it detracts from your argument. So I'm going to read you this. It's a really nice little piece from a judge in Indiana recently, and here's what the judge had to say. The objector's brief on the attorney fee petition contained a variety of accusatory words directed at co-lead counsel. Sleight of hand, efforts to misdirect this court, red-handed double dipping, this nefarious approach. The use of such language mystifies me. It doesn't persuade, it doesn't add credibility to the rest of the argument, and it serves to reduce even further the esteem with which the public sees the legal profession. And I think that's right. You don't have to be snarky, and you shouldn't be. Every now and again, righteous indignation, I'm not above that. If somebody really does something, I feel it needs to be pointed out, I do point it out. But I use that very rarely, and I try very hard not to be snarky. Persuasive versus tutorial, really the tutorial part is what I want to let you think about that tone. And by tutorial, I mean, I'm just giving you this textbook. I'm not going to try to persuade you of something. And oftentimes that can be your best persuasive tool, because there's a subtle underlying message to that. The message could be, just in the simple correctness of your position. I don't have to yell about this because this is just right. Or it could convey subtly your respect for the judge. I don't have to yell about this because I know you're smart and I know you want to do the right thing. So I'm just giving this to you and I know you want to read it. Smart versus friendly. So here again, you just have to know your audience, who you're writing for. Is this a highbrow thing, or are you writing for every man? And Stephen King versus Dean Koontz, I love them both. They both write in the same genre, and their writing is so different. They create, by their words, a different atmosphere. And, you know, if you get everything that you can get in your brief done, you should read it and think what atmosphere are you creating? Because that can help your argument or hurt your argument. And above all, you want to be clear. As illustrated by this really wonderful clip that was from a movie before I was born even, Anti-Name.
Very well,
Now give us our last sentence again.
My puberty in Buffalo was drab.
Oh, no, it has no majesty. Drab is such a drab word.
Oh, how right you are, Brian. It has no affinities. What about bleak?
Bleak? Bleak? How bleak was my puberty? Bleak Buffalo. Hear how the two words cling to each other, locked together like a man and woman in each other's arms. So listen for the word sing.
How bleak was my puberty. I'm sorry.
Come next, Pop. Let's lie down here in front of the fire and stare at the flames. It will help stir the flames of our inspiration.
Now, Brian, do you think the general public is going to understand all this symbolism? Like an echo from the caves of Cockamora, I came forth, whilst Tiedra wept cool tears. Now, wouldn't it be simpler to say, on the day I was born, it rained in Buffalo?
But it's drab.
It's drab, but it's clear.
I used to have a trial ad professor who used to say, you should just call a banana, not an elongated yellow fruit. And that's really true. Clarity is key. And I'm going to tell you, I've never told this in public, I'm going to tell you a personal short story about the importance of accurate communication. So back in the day, at one point in my career, I did all of the tax appeals for the Missouri Department of Revenue. Great subject, great experience. So the financial value of those cases ran the gamut. And in one day, I had 2 oral arguments in front of the Missouri Supreme Court, one with a value of $27.63, and the other with a value of about $90 million. So that $90 million one really was a big deal because it had to do with charging sales tax on credit card transactions. So the director of the Department of Revenue showed up, the Attorney General showed up, reporters were there. There were all the clerks lined up in the back, lawyers came to watch. So I do the argument, and I feel like it's gone pretty well. I get some atta-girls on the way out. So I'm feeling pretty good about myself when the next day I go to the Department of Revenue DMV office to get my driver's license renewed. So I go up to the counter, I'm talking to the lady, she's over there with a little clipboard, she's taking the information, she asks me my name, and I tell her, and she asks me how to spell it, and I tell her, and then she looks up and she says, "Oh, do you work on tax?" Well, I'm famous. I am famous. I am the most famous in the land. Everybody has heard of me, even down here in the bowels of the DMV office. Oh, I'm so flattered. And I say, why, yes, I do. I'm so flattered. However, did you know? And then she looked at me oddly, and now I'm a little confused, and I say, well, what did you ask me? Do you wear contacts? Yeah. So, how to assist clarity in your writing. First of all, you need to set up your points and use roadmaps. That's something we all learned in grade school. Middle school, at the very latest. You use topic sentences, topic paragraphs. I usually make an outline first, and I save a little spot. I write out my argument, and then I fill in. You want to just tell the court where you're going. So the roadmap can take a bunch of forms. I've given you a couple here in the handout. And in my own view, the shorter and more to the point, the better. So the next thing to do is to use logical sequences and transition sentences. So you should follow an order that makes sense and that gives you power as you go along. So for example, if you're a defendant in a negligence case, the order of your argument could be something like this. First, there is no duty. Even if I have a duty, I wasn't negligent. Even if I had a duty and I was negligent, there's no causation. Even if all that is true, you can't prove damages. So you begin if you can, but you always end with strength. If you have a kill shot, put that first in your argument. But if you don't, then the order of your argument should be such that you win in the end. So you understand that. The example I just gave you, you win in the end. And what is the last thing people remember? They remember the last thing. So kill shot, if you have one. If you don't, order it up. So at the conclusion of each one of these sections, you win. I mean, each one of these sections, and the conclusion, you know, it doesn't even have to be fancy. It can just be your transition sentence. Even if this, I still win because of that. So that's a good way to keep the reader going into a flow that creates a powerful argument. So the next thing to do is to make a story and to create and build a theme. The theme begins at the beginning and it runs throughout the argument. And your story must paint a picture. So you don't want to, I think it's sort of like in front of a jury, you don't want to hit people over the head with something. You want your word choices and the order of your words and phrases and paragraphs to paint a picture and percolate in the mind of the reader and let them draw the conclusion you want them to draw. So for example, look at these two sentences. It was raining. John left the house without an umbrella. The order of that suggests that John was either forgetful or dumb, because it was raining is the thing that has been emphasized as the first thought in your head. And that thought remains in your head as you then read, he left without the house without an umbrella. And you go, well, why would he do that? So look at the next sentence. Now the order is different, and there's a different suggestion. John left the house without an umbrella. It was raining. John leaving the house without the umbrella now is the first thing you're thinking about. Well, he must have been in a real hurry, right? So the order of your words and phrases really makes a difference in terms of the impression that you create. The next tip that I will give you is to look for human interest. This is also something really important, because sometimes what you're talking about in your brief and what your issue is just boring. It's just boring. Has anybody done a DMV case? Anybody done that? Oh gosh. I mean, those UMV cases are just excruciating. Looking through those insurance contracts, they're excruciating. So I had an appeal on one of those things once, and I just thought I was going to die until I realized, well, there's actually public policy here. So I built that up and themed it throughout the brief, and danged if at the oral argument, that's what the court picked up on. And I was standing there thinking, why I just stuck that in there so y'all wouldn't fall asleep reading my brief. But it became a focal point of the actual legal argument. So not only is it good for your position, it's good to keep and maintain the reader's interest. Next, fill in the holes. And really all I mean about this is that if something is important enough to be in that brief, it needs to have relevance to your argument. And if it doesn't, it's just sitting there as a distraction. Also, it's useful to use active versus passive voice. And the reason for that, it's pretty simple, that active voice is just more immediate. You know, it does a better job in bringing the reader into what you're saying, to experience what you're saying. And this next one, oh, please, 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 everybody look at this one. Read that to yourself. One thought per sentence, one thought per sentence. There should be one thought per sentence. Look at this giant, this is actually from a court opinion. It's just giant, and it's separated by 1,000 commas. So don't let your flow be interrupted with a bunch of commas and passive thought and then this, and it's very distracting, it's very disruptive, and it just won't do as good a job for you. The other thing that you can do is to make active use of cases, statutes, and rules. So one thing you see a lot, I see a lot, as the court stated in Smith versus Jones. That's really passive, and that sounds like a law review article. You can take the same quote and insert yourself into it and use it actively within your brief. Obviously, you can't change it so that it's different, that it has a different meaning than originally, but you can do this and you can do it effectively. Next, and very importantly, be credible. You must be credible, it's essential. Obviously, you never misquote, you never overplay either the law or the facts. You never, ever, ever, ever cite a case that doesn't actually stand for the proposition for which you have cited it, because that is a credibility death knell. Maybe less, obviously, but still very important. Please pay attention to that first line that's been italicized. Don't cite a case for Proposition X if your position loses in that case. I can't begin to tell you how often I see this, even from really good lawyers and really good law firms. Somebody has just found a great soundbite and they put it in the brief because it's a great soundbite. But no matter how great that soundbite is, if your position loses in that case, it is not a good case for you. And any opponent worth their salt, including yours truly, will take that and just put it right back in your face. I mean, I even count them up. If I run into a situation where we just had one, we had a motion and the other side had it's like a 52-page thing with all these cases cited, well, I counted them up. How many of those cases did you win in? 2. That's a really good point for your opposition. So don't ever get caught out like that. A few more little ministerial things, use of footnotes. A lot of people don't like footnotes. I personally do like them to maintain a flow of argument, but don't clutter up with them. Headings can be used very effectively as part of the way of telling your story because you can do narrative headings. A lot of people really like that. So instead of just saying the plaintiffs cannot establish duty, you say so-and-so doesn't have a duty because blah, blah, blah. It's just all part of, again, building your theme and telling your story. Citation issues, I don't want to bore you too much with this. Just a couple of things, because really neatness does count. Couple of things, because everybody uses Westlaw now and you cut and paste. Watch out for those superscripts. That's not proper citation, the yellow up there, but Westlaw just automatically does it. It also has this apostrophe font. It's the square one as opposed to the little round one. The hyphens are wrong, so just go through and correct all those things at the end. Last but not least here, get rid of every unnecessary word. In my own opinion, this is the single most important thing you can do to be a good writer. Look at all the unnecessary yellow in that and look how much cleaner and clearer you can make it. There's so many words and phrases that we use all the time, I think just by habit, that just need to go. So for example, every time I see the words here and after referred to, I think here and after. Well, where and else after? It's here in after. Well, yes it is. You don't need to say that. It's plaintiffs herein. You mean not the plaintiffs over there, but these plaintiffs? It's unnecessary. So I want to conclude with laying upon all of you a challenge. The next time that you have a memo or a brief that you've written, go ahead and write it the way that you do. I'm personally very gestalt about my writing. I just put it all out there. I come up with, a really long and involved and, overblown thing. And then I cut it, and then I cut it some more, and I cut it some more, and I keep cutting it. Cut your own work by half. The next time you have something, do a word count and cut it by half. And you will be absolutely amazed at what you find. You will find a talent that you didn't know you had, because then you have to be mindful of the words that you use. So you can use one really good descriptive word for those 10 that you just got rid of. And it will make your writing so, so much better. Because like the perfect mathematical formula, when you strip something down to the bone, what you find is something elegant and essential. And that is your most powerful tool. Thank you.